morning.
Please state and spell your name for the record.
Dr. Chris Johnson, Johnsson.
And what do you do for a living, Dr. Johnson?
I am a psychiatrist, specifically a forensic psychiatrist.
Can you briefly describe your educational background?
Yes, I studied right here at Armadillo High School, graduated first in my class. I went to the University of Armadillo where I obtained a degree in biology with a minor in chemistry, again, graduating first in my class. Then I stayed right here and attended Armadillo Medical School. It's a branch of Lone Star A&M University. And I graduated from Armadillo Medical School with my medical degree.
At this time, the defense proffers Dr. Chris Johnson as an expert in the field of psychology and psychiatry and forensic psychiatry.
Counsel, you want to voir dire also?
Yes, Your Honor. Dr. Johnson, you stated earlier that you're a forensic psychiatrist, correct?
Yes,
And that involves the application of mental diseases or defects to the law, correct?
that is correct.
And how long have you been doing that?
I've been doing it for more than 10 years.
And have you ever been called to court to testify as a forensic psychiatrist?
Yes,
In arriving at your conclusion as a forensic psychologist, you must make some speculations about what happened in the past, correct?
Objection, mischaracterization.
Sustained.
I'm a psychiatrist,
You're a psychiatrist.
not a psychologist.
As a forensic psychiatrist,
Yes,
do you have to understand what was going on at a past time to make your opinion?
that comes into play.
So you have to make some educated decisions about what occurred in the past, correct?
Yes,
Without actually having been there, correct?
correct.
Based upon information that comes from your subjects, correct?
Yes,
And during the course of this, you must speculate about what some of those things are, correct?
based on my expertise and my education and my research, yes.
So you must arrive at some conclusions as to the credibility of the information you base your opinions on.
Yes,
And part of that is determining whether someone has a mental disease or defect, correct?
yes,
And you're prepared to offer an opinion on that here today, correct?
absolutely.
And you've studied psychiatry,
Yes,
and you've administered treatment in the past, correct?
yes,
The difference between psychiatry and forensic psychiatry is that psychiatry deals with the treatment of a patient, correct?
correct.
And here today, you had no courses in law, have you?
No,
Have you studied civil procedure,
no,
criminal law?
Objection, relevance.
Your Honor, the witness is about to testify as to her ability to make an opinion on some legal matters. I'm merely exploring her depth of knowledge of the legal system.
But how does procedure affect that?
Procedure in and of itself does not, Your Honor, but it's a preliminary question to determine the depth of her law practice. My next question would have been, have you studied criminal law? Which I don't think the counsel would consent that's your level. If you would like me to withdraw the previous question, I can ask it.
No, we'll proceed.
Thank you. Dr. Johnson, have you had any courses in criminal law,
no,
criminal procedure?
no, I have not.
No further questions, Your Honor. At this point in time, I don't think that forensic psychiatry is an applicable level of expertise. There's a sufficient level of expertise in forensic psychiatry, Your Honor. The state does not contend that the witness cannot offer opinions as to psychiatric matters. However, forensic psychology has not been substantiated as a verifiable science that is reliable and valid and would help the jury. Counsel has not presented any testimony that would suggest that, nor has the witness made any testimony that would refute that.
So you're saying she's not qualified as an expert as a forensic psychologist or psychiatrist?
I think she's not qualified as an expert as a forensic psychiatrist. In addition, forensic psychiatry is an irreliable science and should not be brought up in court. It specifically testifies to ultimate issues, which is outside of the province of the witness and in the province of the jury based upon the Hinckley Amendment to 704.
Your Honor, have you heard?
Sure.
First of all, the witness has established that she has all the requirements, or at least a few of the requirements required under 702A and the Dahlberg standards, that she has knowledge, training, and experience regarding forensic psychiatry. In addition, there's been no testimony elicited that it is an unreliable science.
Your Honor, there has been substantial amount of testimony that would suggest this is an irreliable verifiable science. And I'll address that in a minute. But the Daubert standards do say that a baseline of knowledge is necessary, but the science in and of itself still needs to be reliable and acceptable here. My argument is that the forensic psychiatry is unreliable and unacceptable. Based upon the voir dire examination just conducted of Dr. Johnson, we have already deduced that she has to speculate, has to judge the credibility of some of the information she has been given based upon no personal knowledge and no firsthand experience. And she has to acknowledge the credibility of people's statements. That is within the province of the jury and not the province of the doctor. To allow her to testify as to Mr. Draft's ability to form criminal intent or otherwise would be invading the province of the jury and outside of the scope of her expertise and the subject of debunked science of forensic psychiatry, which is unreliable in itself.
Your Honor, opposing counsel has already used its own expert witness and proffered this exact testimony that it is now saying is invalid. It has opened the door, and that's to now attempt to shut the door on the defense would be improper.
Your Honor, that is far from the truth. Dr. Chris Chacon testified that Mr. Draft did not possess a mental disease or defect, did not testify as to whether he could conform his acts to the statute of law or know the difference between right and wrong. That is perfectly within the realm of psychiatry, and as I said at the beginning of this voir dire, I would be perfectly willing to allow the doctor to testify as to whether a mental disease or defect is present. However, I am against and object to the doctor being able to testify to whether that mental disease or defect caused Mr. Draft to not be able to conform his actions to the color of law or determine right from wrong.
So you're objecting to the Part B of the test?
Exactly.
Okay. And
I'm not familiar with the Part A or B of any tests.
oh, the insanity, right?
Rule 704, Part B, the Hinckley Amendment, added to the rule specifically for this particular purpose out of an insanity defense case. Specifically says that the expert cannot testify to the ultimate issue at hand at trial. The ultimate issue is not whether Mr. Draft possessed a mental disease or defect, as Dr. Chacon testified to earlier. It's whether that mental disease or defect caused him not to be able to conform his acts to the color of law. And
Your Honor, any Rule 704B arguments at this point are premature and are irrelevant with regards to the witness's actual qualifications and ability to be proffered as an expert in forensic psychiatry.
You're saying your expert can testify to those components of the insanity that this doctor cannot?